It's about a minute after 5 o'clock, so I think we'll get started. Welcome, everyone. Thanks again for joining me this evening for what is our second webinar, Ask Askin, anything in real estate, different topics. Generally once a month, we put these sessions on, and we'll keep you on our email list if you'd like to learn about future seminars. Brief intro, in case I haven't met you or don't know you. My name is Bill Askin. I've been practicing law in New Jersey now for over 30 years, primarily or now exclusively real estate law. I am, unlike a lot of attorneys, I am strictly a planning and transactional attorney. I do not go to court. I do not take depositions. I am available each and every day, all day at my desk or in a closing to work with buyers and sellers. In residential transactions is kind of our bread and butter. We do an awful lot of that type of legal work. We also do a significant amount of commercial transactions, business transactions, people buying and selling businesses, land use permits, site plan approvals, variance, that type of work for the development of real estate. Property tax appeals, that business has kind of dried up over the past several years as prices have increased significantly, if you haven't noticed. But used to do a lot more of that. Then still do some. There's still some valid tax appeals. I think we're doing about 6 or 8 this year, but golly, we used to do 60 or 80 every year. Also handle a fair bit of landlord-tenant, mostly evictions, but certainly represent a number of multi-unit property owners and managing and dealing with tenants. Our office started in Sparta. That's where I started practicing a little over 30 years ago. Been in business for myself ever since. We've got 5 attorneys in our office here in Sparta, and we have a satellite office in Beach Haven down in Ocean County. Most of you know location for real estate, and we try to have a focused attention in the counties where our offices are, in Sussex and Ocean counties, although we do work in just about every county in the state. Actually, I have worked in every county in the state of New Jersey. So the Ask Askin seminars tonight will be probably, I'm thinking, about 45 minutes long, tops, informal question and answer style. So if you look over to the right on your screen there is a little chat box where you can either raise your hand or leave me a message if you have a question. I'd be happy to answer questions during the program or at the end if there's some questions in the chat box at the end. I will address other topics in the future. I talked about that, but today we're going to talk about escrow agreements. And obviously, we're talking about escrow agreements because they are very involved and very common in the process of buying or selling real estate. The process of buying a home obviously involves multiple steps, multiple professionals are involved. There are multiple moving parts and pieces to a transaction, and at various different points in the transaction, these parties, other than the buyer or seller, become involved in the intricacies of the transaction in order to assure the integrity of the transaction and keep things moving forward. An escrow agreement is one way to protect both the buyer and the seller. They're designed to be neutral, right? To be fair to all the parties involved. They should not be slanted to favor one party over the other. The nature of an escrow agreement is that it is a neutral third party or third transaction that protects both the buyer and the seller. And that's the case as long as there is a written agreement and that the written agreement spells out all the rules of the escrow, so to speak. So in general, an escrow agent holds the buyer's or the seller's money while the terms of that contract, that escrow agreement, are fulfilled. If they are fulfilled, it will say what happens, and if they are not fulfilled, the escrow agreement should say what happens. So they are, again, designed to protect all the parties, and the escrow agent is one of the parties to that transaction, and you'll find in real estate generally that the escrow agent is usually an attorney or sometimes the title company. that's involved in the settlement of the transaction. Um, Real estate escrow accounts can be used in other contexts that you've probably heard of. One such other different context is for homeowners with a mortgage on their home. You're probably familiar with an escrow account at the lender. Escrow accounts in that mortgage context function primarily as a savings account. You make your monthly mortgage payment. Part of that payment includes a deposit to the escrow account. The mortgage company in that case is serving as the escrow agent, and that's to protect the money of the homeowner and to protect the bills of the vendors that are going to need to be paid, typically monthly or quarterly or annually. And the payments that come out of the escrow are typically for property taxes, quarterly paid in New Jersey, and homeowners insurance, hazard and liability insurance, which typically the mortgage company pays annually, single premium. If the homeowner is paying their homeowner's insurance directly, they have other options. The mortgage companies generally just make an annual payment, and they get a little bit of a discount for paying it all at once. But the best advice about escrow agreements, if you remember, I talked last month, if you were on that conference call, I talked about use and occupancy agreement. And I said the best advice I have for use and occupancy agreements is to avoid them, if possible, in any way. Best advice regarding escrow agreements is, I'll say, proceed with caution. Make sure it's in writing. Make sure it's as concise and specific as it possibly can be made, and that it's prepared by an attorney with full disclosure of what the client's expectations are, right? So, any business, the biggest complaints about the professionals involved are lack of communication or not meeting the client's expectations. So when creating escrow agreements, you want to make sure that you fully understand what the buyer and seller, in this case in real estate, what the buyer and seller's expectations are, that they are reasonable, and that the escrow agreement complies with or comports with the client's expectations. And when it does, typically we don't have any issues, but when it does not, or when in some cases we've seen, everybody says we're holding money in escrow, but there's no written escrow agreement, it's all verbal. That's the worst possible scenario. So, what is an escrow agreement? Cover kind of things like what it is and how it works, the different uses for an escrow agreement, the different types. In general, an escrow agreement is a contract. It is a contract. It is signed by the parties to that contract, separate. Well, not always separate. It's actually also part of the real estate purchase agreement, but oftentimes there's also a separate escrow agreement for things we'll talk about here in a few minutes. But the agreement has to outline the terms and the conditions agreed to between the parties and the responsibility of each party. They generally involve an independent third party called the escrow agent. And like I said, that third party is usually the attorney or the title company. And the escrow agent, you want to make sure also should sign that escrow agreement. A lot of times I see escrow agreements that are signed only by the buyer and the seller. Well, whoever's holding the money or whatever asset is being held in escrow can and should legally also sign that agreement as a party to that escrow contract. And that money is held until the specified conditions in the contract are met. And that could take anywhere from, an hour to several weeks or months even, potentially, depending upon the nature of the agreement itself. They're common in real estate transactions. The escrow agreement is not limited to information about the escrow agent's identity. It includes who the escrow agent is, their role, the amount of money or funds in the escrow, the acceptable use of the money that's in the escrow. That's an issue that comes up sometimes, right? So we have money in escrow, but the parties can't agree on what it can or cannot be used for. Usually it's money, but it can be other assets such as, I don't know, stocks or golly, even Bitcoin or Documents are also held in escrow, right? We have situations where documents like the deed or other title transfer docs are held in escrow pending release of or receipt of a wire transfer, for instance. That happens. You may have heard of things like a dry closing or an escrow closing, where the seller's transfer docs are going to be held in escrow by the settlement agent pending receipt of a wire from the buyer. So generally, one party deposits money or funds or an asset into escrow. We'll talk about the conditions of the escrow and how to fulfill them then. Once the conditions of the escrow are met, the escrow agent then has the authority to deliver or release the money, the funds in the escrow agreement to the beneficiary or the other party to the escrow. Prior to delivering the funds to an escrow agent, so this is typically prior to delivering money to the escrow agent, a prudent buyer or seller will likely want to create a written agreement that specifies the obligations of all the parties involved. So again, all the parties involved, what are the obligations of the buyer? What are the obligations of the seller? And what are the obligations of the escrow agent? And the agreement can and should typically contain the name and address of the buyer, contact information, phone numbers and emails, same information, name, address, phone and email for the seller, and same information for the escrow agent. You want to make sure that everybody knows how to get in touch with each other to coordinate and fulfill the terms of the escrow. The amount of the escrow should also be included in the escrow agreement. Exactly what is being held, defined. Typically, it includes an amount of money. Also, that agreement should contain the conditions that must be met before the escrow agent releases the funds from the escrow, and who the escrow agent will release the escrow funds to once all the conditions are met. The escrow agreement should also contain deadlines. Really, really important, right? So you don't want to have money in escrow forever, right? So if the conditions of the escrow say it's conditioned upon a septic repair or replacement, and you don't want to leave that open-ended, right? So if the seller is going to have to repair or replace a septic system or any component of the house post-closing, you want to say the money will be released to the seller when that repair is completed or on September 15th, 2023, whichever is later or whichever is earlier. Makes sense, right? So that if the seller doesn't do whatever the seller is supposed to do in that situation, the money in the escrow will be released to the buyer so the buyer can handle whatever that issue might be. Deadlines are very, very important. Also important are acceptable use of the funds being held by the escrow agent, right? So if the money is being held in escrow to repair or replace a septic system, for instance, does that include the escrow agent can use the money to hay and seed, right? Plant new grass once it's all done. Does it include, can the money be used to repair any other damages to the property that may be done during a new septic installation? For instance, we've had situations where watering systems, sprinkler systems were damaged. It should say in the escrow agreement whether or not the money can be used for such things like that. It should also contain what the duties and liabilities of the escrow agent are, right? So very often the escrow agent has served as the attorney for the buyer or the seller in the transaction, underlying transaction. Right now that transaction is closed and the attorney is staying involved as the escrow agent. Well, now that attorney's duty of loyalty is kind of broken from their own client, right? Because now they're working for both the buyer and the seller. And is the attorney who stays on as the escrow agent then allowed to go back and represent his client, his buyer, for instance, if an issue comes up over the escrow, and who gets it, right? So if I'm the escrow agent, I represent the buyer, I handle an escrow, I'm the escrow agent, now I'm the escrow agent as a neutral between the buyer and the seller. Something blows up, whatever, the seller wants the money, the buyer wants the money, and we got to go to court. Can I go to court and represent just the buyer? Under the ethics laws that we're bound by, the answer is generally no. But we should have that spelled out, that once the escrow agent is appointed and takes on the authority and the responsibility to serve in the interest of both the buyer and the seller, that the agent can no longer go back and be loyal to or have a fiduciary relationship with only his or her prior client. Let's go over some different types of escrows, and one is very common. In fact, it's involved in pretty much every real estate contract that involves deposit money, right? The most common form of an escrow is the deposit, or what is often referred to as earnest money. It's used to convey, earnest money is used as consideration. It's used to convey the buyer's sincerity, right? Sincerity of interest in the property, and to display the buyer will use their earnest or good faith efforts to comply with the terms and conditions of the contract and close on the property, right? So how much earnest or deposit money do we generally recommend? Is it required? Are you required to take a deposit, earnest money or deposit money from a buyer? No, it's not required by law. I've closed deals where there was absolutely no deposit money or earnest money. But generally speaking, we always see it, especially in this market we're in right now, right? In this kind of a seller's market where there are multiple offers, it seems, in almost every listing. One of the ways to, put your buyer's best foot forward is to get them to put up pretty significant earnest money or deposit money. How much is always the issue. What's the answer to that question? I think it depends on the market. And I think in this market that we're in right now, the more the merrier. It used to be when I started in this business over 30 years ago, 10% was pretty much routine. Almost every contract, we had 10% deposit money. And it seems to have dwindled over the years. I think for a while it was at 5%. So now we see, contracts with 1,000, 5,000, 10,000. There is no answer. But in this market, I think that's one of the things that sellers are looking at. It's one of the things that listing agents are reviewing with sellers when they get multiple offers. How serious is this buyer? And if the buyer comes in with 10 or 20, we've even had 50% deposits from day one in order to secure a house in a multiple offer bid for a buyer, whatever it takes. If the buyer is really serious and there's one house and one house only, and there's going to be 10 or 20 or 30 offers I've heard this year, it's crazy, right? You want to put your best foot forward, put a significant deposit down. That money is held in escrow. Under the terms of the escrow, they're spelled out in your realtor form contract. They're often, almost always, revised in some fashion in the attorney review contingency of the contract. There's some pretty general language that's used to protect both parties and to protect the escrow agent in terms of who's holding that money. A lot of times the buyer will write a check to the real estate broker and we'll revise that and say, no, the money's going to come to the attorney, or sometimes even to the title company. In fact, the New Jersey real estate form contract was recently updated to say that it'll be held by the title or settlement agent. We usually try to revise that and have the attorneys hold it. It just makes it a little bit easier for the attorneys to manage the process and prepare for closing. So in that general, most frequent use of an escrow agreement for deposit monies, when is it released? Well, it's released, the agreement will say, upon closing of title to the seller, right? Released to the seller, and it's a credit to the buyer towards the purchase price. What happens if the buyer does not close? Does the buyer get the escrow money back? Well, you got to look at it at the escrow agreement, right? And to look at why it did not close. Did it not close because we could not conclude the inspection contingency? Well, as long as we were unable to complete the inspection contingency within the inspection or due diligence time period, the answer is generally yes, that the buyer would get that escrow or deposit money refunded to them. If the buyer could not get a mortgage commitment, We'd have to look and make sure there is a mortgage contingency in the contract. We have an awful lot of them where there is not. If it's a cash buyer, obviously that's not an option. But the mortgage commitment contingency has kind of been a hotbed for claims these days, because oftentimes the mortgage commitment is waived, or the mortgage contingency is waived, or a mortgage commitment is issued based on with a condition that the house appraised for a certain price. You may have had that situation, and we've had a lot of low appraisals recently, right? So now the mortgage contingency expired, and the buyer moved forward because they have their commitment, but then 10 days before the closing, we find out that the house underappraised, and now the buyer can't get their loan or get their mortgage. So does the buyer get their deposit money back? Depends if the seller agrees to release the money. What if the buyer just gets cold feet? Do they get their money back? Probably not. Probably not. It's subject to a negotiation. What if the buyer loses their job? Do they get their money back? Probably not, unless there's a specific contingency that says the contract is contingent upon the purchaser's continued employment through the date of closing. What if the purchaser dies? Right? Had it happen. People pass away. What if the purchaser dies? If it's cash, they don't get their money back, and the estate is still required to close unless there's different language in the contract and in the escrow agreement. So once an event happens where a contract is not going to close, when does the money get released, right? If we had a $50,000 deposit that's being held in escrow pending a closing, and now it's not going to close, when does it get released? Well, it only gets released at closing. If there's a closing, or if there's not going to be a closing, it can and is only released upon a written agreement between all the parties. So generally what happens, and if you've been practicing real estate for a number of years, you know that when this does happen, when a deal falls apart, it's the beginning of a whole nother negotiation, right? What's going to happen to the deposit money? And the first place to look to find the answer to the questions that are raised is the escrow agreement itself. And hopefully it's very specific, but in general, as long as the buyer used good faith efforts to comply with the terms of the contract, and they are still within the inspection or due diligence contingency, and they couldn't get they couldn't negotiate a resolution of the inspection contingency with the seller, the buyer's going to get their money back. If during the mortgage contingency, they were not able to get approval for the mortgage and get a mortgage commitment, and they decide to terminate, in general, they're going to get their deposit money back. But what's the seller's rights? And what do we see sometimes? The seller says, well, wait a minute. You didn't use your good faith effort to get your mortgage commitment, because between the date of the contract and today, you went out, and I've had this happen. You went out and bought a brand new car, and now your debt to income ratio went a little bit higher, and you no longer qualify, and that's not good faith efforts to get your mortgage. So I know they teach this in real estate school. When you are working with buyers, make sure that they don't go out and open up new lines of credit or buy new cars or do anything that's going to affect their credit in that way between the date of the contract and the date of the closing. I know they're excited to buy new stuff like new furniture and run up their credit cards, but don't do it until after the closing, because that'll create issues with the deposit money if the deal doesn't go through, and it could certainly impact their credit and the odds of them getting the mortgage to close. So those are the two ways to get money released from escrow, either from deposit money released from deposit escrow. One is at the closing, or two is upon written agreement between all the parties. And if neither of those two things happen, guess what happens? The money stays in escrow, and the escrow agent could be me, could be another attorney, could be a title company. Our hands are tied. We can't, even though the money in that account might be my client's, right? That could be my buyer's money in that account. I'm obligated to fulfill the responsibilities and liability of an escrow agent and fulfill the terms of the agreement, which say the money can only go back to a buyer or to the seller upon a written agreement or a closing. And it stays in escrow then until there is a written agreement, or what else? What's the final and only other way to get it out of escrow? It's a lawsuit, right? Yeah, one of the parties has to go to court, file a complaint, There's litigation over the terms of the escrow, and then a judge will decide who gets the money in the escrow account. Um, so that's every transaction. You know, you want to tighten up and talk to your clients about the importance of deposit money and money held in escrow. I still say, despite the you know the downside of having money held in escrow and the potential for litigation, it's very rare. It's very rare that it ends up in court. And again, if you have a really serious buyer and a one-of-a-kind house that they just have to have, you want to get a very hefty escrow deposit in order to represent your buyer and try. And same thing with the listing agent. You want to look for the terms of the contract, not only just the highest offer, but the best offer. And sometimes the best is the offer that has a very small or no mortgage and a very high amount of deposit money up front to be held in escrow. And in my experience with buyers, if you're showing houses to buyers and they come back to the deposit money and they put $1,000 in escrow, the buyer hasn't really bought the house, right? They go home and they could change their mind that night. But if the buyer writes a check for $50,000, say the husband and wife, they're going to go home and talk about how excited they are about their new house. They bought the house if they wrote a check for $50,000 up front. $1,000, it doesn't always seal the deal. And serving as an escrow agent, that carries also a lot of responsibility and liability for the escrow agent, which again is usually an attorney or a title company. And folks, we gotta have to take that obviously seriously. My license to practice law is at stake every time I'm the escrow agent, and I am very thorough, very cautious, and very strict about the development or drafting or preparation of the agreement itself, and then fulfilling my liabilities and responsibilities as the escrow agent. Again, the agreement has to have or should have the escrow agent or my contact information, definitions, expressions pertinent to the agreement, details not only of the amount of money or assets in the escrow agreement, but specifically what they can be used for, and then the details of how and when they can be released, right, to either to the seller at the closing or to the seller at post-closing if this money's being held for some use after the closing, or to the buyer post-closing if the seller's remaining in the property and there's a use and occupancy agreement, and some of the seller's proceeds being held to pay rent, to pay for security deposit if there's post-closing damages, things like that. The escrow agreement should also contain the escrow agent's fees, right? If the escrow agent is going to charge anything for serving as the escrow agent, the escrow agent's expenses and fees really need to be in the escrow agreement itself. I typically don't charge for that service unless it's a very prolonged post-closing escrow agreement where I'm going to be managing the account and writing checks for things like post-closing repairs, new roof, new septic, new furnace, things like that. I would charge generally a flat fee of a couple $100. The escrow agreement should also contain the jurisdiction and venue in the event of any legal action. So it should state that if there is a disagreement or we're not able to negotiate the release of the escrow, that any litigation over the terms or the release of the money, the jurisdiction and venue for such litigation would be in the county, usually in which the property is located. So if I'm closing on a contract property in Ocean County, the jurisdiction will be in the New Jersey Superior Court in Toms River. Same thing for whatever other county it might be in. So beyond the typical deposit situation, the earnest money, which is held until closing or termination of the agreement, there are several other types of escrows that are on occasion that become involved in real estate closings. One is kind of the topic that I talked about last month is a use and occupancy agreement. And in that case, generally you're going to hold an escrow amount of money. If this is a case where the seller is going to remain in occupancy of the property post-closing. You're going to hold an amount of the seller's proceeds right from the closing. Money or check is written from settlement to the escrow account for an amount of money that's sufficient to cover at least and usually more than the seller's obligations to the buyer. To the seller now becomes kind of a tenant, and the buyer becomes a pseudo landlord under terms that will typically require daily rental payments or weekly rental payments. You want to hold enough money to cover the term of that U&O. So if it's a 30-day use and occupancy agreement and the rent is $100 a day, you're going to have $3,000 held in escrow to cover the potential rental payments that will be due until the seller vacates. And you want to have that escrow agreement state that the money can be released periodically to the buyer, whether it's daily or weekly or monthly or just at the end of the agreement. You want to also add to that agreement, most likely you're going to have an escrow, an additional amount to cover what happens if the seller doesn't occupy or doesn't vacate the property within the 30 days that are required. So the use and occupancy agreements I covered last month typically will have a penalty rental payment due that's double or triple the daily rent. So that if you're going to have, 30 days is 3,000, the next 30 days will be at 6,000 a month. Now you're going to want to have, probably $9,000 in escrow. Then what happens if after closing, the seller still occupies the property and damages the property? They make holes in the walls, they break windows moving out, they damage the washer or dryer if it's included in the sale, or God forbid, the house burns down or needs a new roof, something major happens. You want to have some money, just like a landlord tenant in a lease agreement. You want to have some sort of security to protect the seller's potential exposure there, or the buyer's potential exposure there if that happens. And those become very, very complex. So if you're going to have a use and occupancy agreement, whether the seller is staying after closing or, we've had, on occasion, buyer's occupancy prior to title transfer, you want to have a very detailed agreement, use and occupancy agreement, and a very detailed escrow agreement to govern and control the terms of the assets that'll be held in that escrow. If the buyer is moving in early, if the seller is going to let the buyer in prior to closing, not a real good idea, in my advice to my clients. But there are certain situations where there may be no other option. Same thing, before the buyer or before the seller ever considers allowing that buyer in, get some pretty significant escrow money. So again, the escrow in that case should be enough from the buyer to cover their rental obligations, a penalty if they don't close when they're supposed to close, penalty rent, security deposit, and deadlines, right? And a deadline for performance by the buyer. Let's see. So that's an escrow for use and occupancy agreement. How about escrows for post-closing work? In areas where there are septic or wells, we do see escrows for repair or replacement of those types of utilities that can't be done in time for closing, and the buyer needs to close or wants to close, the seller wants to close, there's a rate lock that's expiring that's going to cost a lot of money, etc. We do on occasion close sales with post-closing escrows for things like septic or well or any utility in the property. And we take the estimate. Again, my recommendation or advice in these situations is to take the estimate, the best proposals to complete all the work, and deposit 150% of the proposal or the estimate for that work to be done into an escrow account. So typically a closing happens, again, immediately directly from the closing, a check is written to the escrow agent. And if the cost of I'm going to use a septic repair because that's usually the biggest, or a septic replacement. If the estimate to get it repaired is $40,000, we're going to require, if I'm the buyer's attorney, 40 plus another 50% or 20, a total of $60,000 be written from the settlement agent to the escrow account. And we're going to have a very detailed escrow agreement that says exactly what the money in that account can be used for. Typically, you're going to see a generic one that says for the repair or the replacement of the septic, and that's fine, but it's not great because what if other issues come up? And we've seen these over the years. What if there's damage to the landscaping? What if in order to install this system that all the bushes along the foundation and the front of the house have to be removed? Well, can the escrow be paid to redo all the landscaping? Can it be used for driveway repair? Very often, if you're in the business where there are septic systems, driveways get damaged by the heavy equipment that's used to install a septic. Can the escrow be used to repair the driveway? Can it be used to put seed and hay, reseed the lawn after the work is done? Have deadlines in there. We talked about deadlines. What happens if a year goes by and the seller just never gets the septic completed? There's got to be a point in time where the escrow ends and the money is released to the purchaser. Other escrows we often have escrows for final readings, right? If we can't get an absolute final reading for water and sewer, we may hold an escrow for the final water and sewer bill. Once that's received, the payment is made from, again, the seller's proceeds. We hold escrow from the seller's proceeds, and then the balance of the escrow would be returned to the seller post-closing. I very, very often see that is the case, and there is no written escrow agreement. Typically, that's going to be okay in 90% of the cases, but 10% it's not. What if the escrow agreement they make that agreement, right? So they're going to hold, I don't know, $400, $500 from closing for pending the final water and sewer bill. And between closing and receipt of that bill, for some reason the water's left on at the house, right? Or there's the pipes burst in the house. These things happen, and now the water bill's $1,500 or $2,500. Who pays for that? Arguably, who knows? Did it happen before closing or after closing? You want to make sure those issues are addressed. We also have escrows for dry closings, right? So sometimes we get to the point where we're at a closing and the sellers delivered their documents, transfer documents, and the buyers signed all their documents and closed, but the mortgage company hasn't released the wire to fund the mortgage, and we can't confirm receipt of the funds. And now it's 5 o'clock on the day of the closing. We're going to finish that closing in escrow, right? And the seller's transfer docs are going to be held, in this case, typically by the title company or settlement agent. They're going to be held in escrow, pending receipt of the funds to close from the buyer or the buyer's lender. Again, typically there is not a written agreement. I always enforce in my closings that we have a written agreement, because things happen, right? So put that in writing. It's a very generic boilerplate 2 or 3 paragraph agreement, but have an agreement signed by who? In that case, all 3 parties, so they understand and agree: buyer, seller, escrow agent, in this case typically the title company or the settlement agent. They agree, closed in escrow, meaning that there hasn't been a title transfer. That night, liability is still on the seller. They still own the house, pending receipt of the buyer's funds, at which point the closing is concluded. The transfer docs are released from escrow to the buyer. The money in escrow, the buyer's funds to close are released to all the parties involved. The title company, the mortgage company's fees, the lawyer's fees, the title fees, and the net to the seller. Then and only then is it done, and everybody is protected. Now, some of the additional considerations and things that come up routinely: who pays for whatever the escrow is being held for? Who pays if the amount held in escrow is not enough, right? Is it possible that the amount of money, even if you hold 150% of the estimated costs that are going to be involved, who pays if it's not enough, right? Who pays if the seller occupies for 90 days after closing and doesn't, the rent that we held in escrow is not enough to pay the seller's obligations? Who pays? Well, the answer is, look at the escrow agreement. What does it say? if you look at these agreements, if you have old agreements, look at them. Most of the time, you're going to see it doesn't say. We see it all the time. Somebody prepares and sends me an escrow agreement, and it looks great. But then I say, well, who pays if that's not enough? That should be answered in the escrow agreement. It should say, if the amount of money being held in escrow for the well test or the CO or the smoke certification or the repair or replacement of the furnace or the step, if it's not enough, the remaining balance is the responsibility of buyer or seller. Resolve it ahead of time, because if you don't, if it's silent, if it doesn't say that, guess what happens? We go to court and a judge decides whose responsibility it is. And the buyer and seller pay the lawyers a lot more money to go to court. I don't go to court. I'd have to get another attorney to handle that. But again, it creates frustration. It creates waste of time, certainly adds a lot of aggravation and frustration, and ends up costing our clients a lot more money. Who's responsible if the amount in escrow is not enough? What if there's a request for payment from the escrow, from the buyer or the seller, that's not contemplated by the terms of the escrow agreement? And that's the situation where there's like collateral damage to the property, collateral damage as part of a repair, collateral damage of whatever might happen. Again, if the specific request for payment for an issue, if that's not permitted by the language in the escrow agreement, I, as the escrow agent, I can't release it. I can't write a check to a landscaper to plant bushes when the escrow agreement says that it doesn't say I can do that. If the escrow agreement just says that it's for the repair and replacement of the septic, right? I can only write checks to the septic engineer and the septic contractor, period. Otherwise, I have liability. So you want to look and make sure that those agreements, number one, our clients understand them, that their expectations are clear, that their expectations are met, and that the agreement is as thorough as it possibly can be. Because unless the escrow agreement says that the escrow agent can pay for something, the escrow agent's hands are tied. And then what happens again? Either the parties agree or disagree and come to some kind of an agreement, and they amend the escrow agreement and say, okay, that, Bill or whoever the escrow agent is, you can pay to replace the street light that was run over by the backhoe from the escrow if that happens. Unless they agree to amend it and say, okay, Bill, both parties say you can do that. They don't come to an agreement, it goes to court and a judge would decide. Only way it can happen. And I kind of covered earlier, what if the parties don't agree on the release of the escrow? If neither party files litigation, neither files a complaint in court to release the escrow, and this happens more often, with deposit money, and there's only $1,000 or $2,000 deposit being held in escrow, and the buyer backs out, and the seller says they didn't use good faith efforts or they weren't earnest in their efforts to buy the property, and the buyer says, yes, I did, and they bicker back and forth a little bit, and the attorneys write threatening emails, and nothing happens, and neither party files a complaint. It just sits in an attorney or title company's trust account for a year or two. Eventually, it's turned over or released to the state of New Jersey and becomes unclaimed funds. It's frustrating for all the parties involved. Frustrating for the attorneys. We can't, our hands are tied. We can't do anything. And typically that happens when there's not much money in escrow. If somebody has $50,000 in escrow, they're going to take some action, whether it's a good faith negotiation to get it released or satisfied somehow, or they're going to go to court if there's a significant amount of escrow. The escrow agent's fees, if there are any, the agreement should say who pays those, right? So escrow agents are entitled to fees. Some title companies charge an escrow fee. You can see it usually on the settlement statement on the HUD-1 or the settlement statement. Again, they should be in black and white and spelled out in the escrow agreement. Attorneys, like I typically, if it's a post-closing escrow for a significant amount of money in a significant amount of time, I would have a flat fee, usually a couple $100. It would be listed in the escrow agreement. So that kind of covers it. That's about all I have. I don't think I have any questions. Does anybody have any questions or Q&A? Anything in the chat? Kathleen, I didn't. Kathleen's on here. Um, I didn't see any. No, no questions yet. So in the next couple minutes, if you have anything, type it on in there. I can't open up the microphones because we tried that once and it got a little hectic. But if you put something in there in chat, I would be happy to answer it. Um, like I said, I'm a real estate legal practitioner. Do nearly 100% real estate transactions. I'm happy to help each and every one of you in any way I can, whether it's you want to shoot me an email for a question, or if you have need to have us help you with a buyer or seller in a transaction. We're going to continue with these monthly Q&A, Ask Askin branded little thing. If you have any other topics you'd like me to address in the future, you could put that in the chat box as well. Like I said, we've done use and occupancy agreements. This kind of covered escrow agreements. We'll cover maybe the attorney review process at some point, contingencies in contracts. There's a lot of contingencies. In fact, one that a lot of people I'm recommending now is in a buyer's market, we see a lot of home sale contingencies, right? They're gonna sell my house only. I'm going to buy this listing only if I can sell my current house. So I make an offer. I want to buy the house contingent upon the sale of my current house. Those aren't flying right now, right? Because there's multiple offers and home sellers know there's high demand. They don't want to take the risk of a home sale contingency. But here's an idea. Think of the reverse, right? You've got a lot of people that would potentially buy another house if they could find the house that they can buy, but there's nothing on the market. They can't find the house that they want to buy, so they're not listing their house, right? A lot of people would sell if they could find the right house to buy, but they're not going to sell till they find the house that they buy. And I think a good dialogue with them is the home purchase contingency, right? You say, Mr. and Mrs. Seller, hey, I know you don't want to list right now because I can't find the home that you want to buy, but there are a lot of sellers in your same situation telling me the same thing. They're not listing because they can't find anything to purchase. And by listing your house does not by any means say you have to sell, right? But by listing your house, that would be the start of a process by which you could start looking for other houses. And if in the meantime you get an offer to purchase your home, you could negotiate and make it contingent upon purchasing your next house. In fact, I got one today where the sellers agreed to sell their house contingent upon them being able to negotiate the contract and clear the attorney review contingency on a replacement residential property within 30 days, right? So if they cannot get the house they want to buy in 30 days, they can get out of the sale of their house. Really good technique for this particular market where we've got kind of a stalemate out there right now. I think a lot of people want to sell, but they're not listing with you because they can't find the house they want to buy. So if you can talk to them about that. That might be something to get them motivated and kind of break the gridlock that we have. I still don't see any questions or anything in chat. I don't think. Does anybody? People. All right, Lori Mantilla, I just opened up your microphone. Do you have a question?
Bill.
Yeah.
Hi. No, this is great. I love these sessions. I learned so much. My question was, when will you be having your next one and what will it be on?
In June, probably the third
Okay.
week in June. I generally do them on a Wednesday, 5 o'clock on a Wednesday, the third
Okay.
Wednesday of the month. I just need to confirm that my schedule will permit that next month. And why don't you? Do you have a suggestion for a topic?
Let me think. I don't at this moment, but I can email you if I can. If I think of anything really pertinent.
Yeah. I mean, I'm thinking the topics are generally, attorney review, contingencies is a big one. I used to do seminars on home sale contingencies. There are none of
That's
those right
great.
now. There are no home sale contingencies, right? No
There's
seller is
not,
going to
right?
take an
There's
offer
not.
that's contingent upon a buyer selling their house.
No.
They don't have to. But think of the opposite, because this is kind of the opposite market from
Right.
a buyer's market where home sale contingencies work.
Yep.
How about a seller's market where a home purchase contingency, I think, is a great tool. So,
And Bill, with no inventory, that's genius.
so all right.
I don't know if you heard me, but I said.
I did. I heard you. Thank
okay,
you.
I'm sorry. I just wasn't sure.
I think I just shut off your microphone.
No, that's okay. That's okay.
All right.
I'm okay with that.
Any other questions? Don't see any. So look for it. It will most likely be the third or fourth Wednesday in June. And I'll pick a topic, probably something with contingencies, mortgage contingencies, inspection contingencies, due diligence. Inspections are always a big one. What is legit? Like, right? What can and what kind of what can a buyer and cannot, what kind of buyer cannot expect to reasonably request after a home inspection, right? Can they ask that the dripping faucet be replaced? Talk about things like that. So thanks, everyone. Have a great evening.
Bill, I think inspections will be great.
All right. Thank you.
Thank
All right. Good night, everyone. Thanks for being here. We'll see you again.